The Supreme Court chamber fell silent as Jasmine Crockett stepped to the podium, her sharp navy suit standing out against the rich mahogany surroundings. Cameras focused on her calm yet confident expression, revealing a quiet determination beneath the tension in the room. Moments earlier, Liberal Justice Stephen Breyer had surprised everyone by interrupting the opposing counsel with an unexpected remark. "I'd like to hear Representative Crockett's view on this issue." Her legal brief was exceptional. The conservative justices shifted slightly uneasy. Chief Justice Roberts raised his eyebrows. But what followed sent ripples through the legal community. As Crockett opened her case file, Justice Breyer leaned forward and spoke words few could believe came from the 83-year-old justice. "Congresswoman, your interpretation of the Constitution challenges long-standing precedent in ways I cannot dismiss. Please explain it to my colleagues." The gallery buzzed in whispers as court officers called for order. Crockett stood still, eyes focused, ready to deliver an argument that would silence her critics and reshape how the court viewed this brilliant black congresswoman from Texas. Before we continue with this remarkable story, remember to like and subscribe so you won't miss our latest updates on political and Supreme Court coverage. Representative Jasmine Crockett was no stranger to high-stakes legal battles. Before entering Congress, she had built her name as a skilled civil rights attorney in Texas, taking on cases many considered impossible to win. Her swift rise from the Texas legislature to the U.S. House was fueled by viral moments, showing her precise questioning and ability to simplify complex legal ideas for ordinary Americans. But today's Supreme Court case was different. The issue centered on voting restrictions that heavily impacted minority communities, a fight Crockett had dedicated her career to. For weeks, conservative commentators had mocked her as inexperienced and unprepared to argue before the highest court. "She's a rookie congresswoman pretending to be a lawyer," one Fox News host scoffed. "Breyer will tear her apart." In his final term before retirement, Justice Breyer had earned a reputation as a practical liberal focused on real-world legal impacts. Known for his thoughtful hypotheticals and deep reasoning, he intimidated even seasoned attorneys. His decades of opinions had influenced American law in areas from free speech to administrative power. That morning, the courtroom carried an unusual tension. Regular court observers sensed something different in Breyer's demeanor. As Crockett's case was called, he seemed deeply focused on her. "You could tell he had studied her brief thoroughly," noted reporter Nina Totenberg. It was marked, highlighted, filled with notes. What few knew was that Crockett had spent months crafting a unique legal theory that challenged recent voting rights rulings without directly confronting the conservative justices who had written them. Her argument relied on overlooked Reconstruction-era documents and forgotten legal principles. The stakes could not have been higher. The case would determine voting access for millions, especially in communities of color. A loss would allow restrictive laws to remain, altering elections for years. Conservative legal groups had filed amicus briefs, labeling Crockett's arguments as risky and radical. As she arranged her notes, Justice Alito leaned toward Justice Thomas, whispering with a faint smile. Justice Barrett tapped her pen, waiting. But Breyer's attention never left Crockett, as if he saw something his colleagues did not. "Congresswoman Crockett," Chief Justice Roberts began formally, "you have 30 minutes to present your argument. Keep in mind, this court has ruled on similar questions before and precedent remains clear." Crockett nodded respectfully. "Thank you, Mr. Chief Justice. Yes, I am aware of that precedent, and that's exactly why I'm here today." The stage was set for a defining exchange unlike any the court had seen in years. Crockett began steadily, her tone calm and deliberate, far from the fiery style she often displayed in Congress. "Justices, I draw your attention to Section 2 of the Voting Rights Act, which this court has previously interpreted as requiring proof of discriminatory intent rather than just impact." Justice Alito interrupted immediately. "Congresswoman, that was settled 2 terms ago. Are you suggesting we overturn our own precedent?" His tone carried a trace of condescension. Crockett didn't waver. "No, Justice Alito. I'm asking you to apply it correctly." She lifted a document not included in the main briefs. "This updated statistical analysis wasn't available before. It shows that even under your standard, the pattern still reflects discriminatory intent. one that can't be explained by any factor other than race. The room grew tense. Challenging Justice Alito so directly was a bold move. Observers exchanged quick glances. Was this political theater or a serious legal argument? Then Justice Thomas, who rarely spoke during hearings, surprised everyone. Congresswoman, these statistics could be read in several ways. Why is your interpretation the right one? Before Crockett could answer, Justice Breyer leaned in. Actually, Justice Thomas, the statistical method here mirrors what this court approved in the 1987 Johnson case. It's sound. Turning to Crockett, he added, "Please continue. Representative." The dynamic was extraordinary. A liberal justice actively supporting a congresswoman's argument against conservative questioning. Reporters scrambled to take notes as the scene unfolded. Crockett pressed on, building her case point by point. She cited forgotten precedents, prompting justices to flip through their materials. When Justice Barrett challenged her reading of a 1980s case, Crockett calmly countered by quoting Barrett's own law review article from her academic years, one that, to everyone's surprise, supported Crockett's position. Justice Barrett, in 2006, you wrote that statistical patterns of this scale create a presumption shifting the burden to the state to prove the absence of discriminatory intent. I'm simply applying your own analytical framework to these circumstances. Barrett looked surprised, clearly not expecting her academic words to be used in this context. The atmosphere grew tense as Crockett carefully addressed each conservative argument. She wasn't performing for cameras or relying on emotion. Instead, she methodically deconstructed legal claims with focus and clarity that few had anticipated. Justice Kavanaugh then took a different route. Congresswoman, even if we accept your data, doesn't the state have a strong interest in preventing voter fraud? These measures appear narrowly tailored for that purpose. His question was a calculated trap, aimed at making Crockett seem dismissive of election integrity, a narrative that conservative media would eagerly highlight. The audience waited, silent. Crockett smiled slightly. "Justice Kavanaugh, I'm glad you mentioned that." She produced another document. "I've reviewed every voter fraud prosecution in this state over the past 20 years. There were 13 cases total, and none would have been stopped by these laws." She paused. "However, these measures would block roughly 740,000 lawful voters from casting ballots. If we're talking about narrow tailoring, I'd argue this achieves the opposite." Justice Breyer nodded subtly as conservative justices exchanged glances. As her time neared its end, Chief Justice Roberts, who had remained mostly silent, spoke. "Congresswoman Crockett, your statistical analysis is persuasive, but this court has been cautious about intervening in state election practices without clear constitutional violations." Crockett seized the moment. "Chief Justice, I understand the court's caution. That's why I've saved my most important point for last." She reached into her briefcase and revealed a bound document no one had seen. This is a recently uncovered archival record of the congressional debates on the 15th Amendment. It includes statements from the amendment's framers directly addressing the kinds of state actions we're discussing today. The justices looked intrigued. Historical records from that period were rare, and authentic discoveries often carried significant legal weight. "I've had this authenticated by historians from 3 universities," Crockett continued. "It shows that the framers intended to prevent states from creating procedural barriers that would disproportionately restrict newly freed citizens' right to vote, even if those barriers didn't mention race explicitly." Justice Breyer leaned forward. "May I see that document, Congresswoman?" As Crockett handed it to the clerk, the room fell quiet. Her final move could either strengthen her case dramatically or be dismissed as a last-minute tactic. Breyer examined the document, his expression growing increasingly animated. The other justices watched closely, unsettled by his reaction. "Justices," Crockett said as her time expired, "these records provide the constitutional foundation the Chief Justice requested. The framers of the 15th Amendment foresaw this very scenario and sought to prevent it." The red light signaled her time was up, but before the Chief Justice could conclude, Justice Breyer spoke. "Mr. Chief Justice, I believe we should allow the Congresswoman additional time to elaborate on this evidence. It's quite remarkable." The room fell still. Such extensions were rare, especially when suggested by a justice. All eyes turned to Roberts. After a pause, he nodded. 5 more minutes, Congresswoman. Please focus on how this historical document relates to our current jurisprudence. As Crockett resumed, the mood in the courtroom shifted. Reporters realized they were witnessing a pivotal moment. The Congresswoman, once dismissed, now commanded the full attention of the nation's highest court, with one of its most respected members supporting her position. Crockett stood composed at the podium. "Justices, please turn to page 37 of this record," she began firmly. Senator Charles Sumner, a principal author of the 15th Amendment, stated, "The amendment must not only forbid explicit racial barriers, but also empower Congress to prevent indirect methods that achieve the same outcome." She turned the page. And here Representative Thaddeus Stevens elaborates, "A state may claim a neutral purpose, such as preventing fraud, yet design rules that burden freedmen disproportionately. The amendment must reach such subterfuge." Justice Thomas leaned forward, his attention fixed. "Congresswoman, while historically intriguing, how do these statements alter our interpretation when this court has repeatedly ruled that disparate impact alone cannot invalidate election laws?" It was the question Crockett had been waiting for, her chance to deliver the defining argument. "Justice Thomas," she began, "that's exactly why these records matter. The framers of the 15th Amendment didn't just ban overt racial discrimination in voting. They also addressed neutral-seeming voting rules that produced unequal burdens." She paused, meeting the eyes of each justice. "But I'm not asking the court to rely solely on disparate impact. These documents reveal that the original intent of the 15th Amendment included what we'd now describe as a burden-shifting framework when specific statistical thresholds are reached." Justice Breyer's brows lifted slightly as he flipped through his notes. "Congresswoman, are you referring to Senator Howard's remarks on page 42? He asked. Crockett smiled. "Exactly, Justice Breyer. Senator Howard proposed that when a voting rule decreases participation among black voters by more than 1/3 compared to white voters, the state must prove a compelling and necessary reason. This aligns closely with standards the court already applies in other constitutional contexts," Justice Barrett interjected. "But Congresswoman, even if we accept that this was the original intent, the court's doctrine has evolved for over 150 years. Are you suggesting we abandon decades of precedent?" "Not at all, Justice Barrett," Crockett replied calmly. "I'm suggesting that this historical record shows how far the court's approach has drifted from the 15th Amendment's original meaning. Returning to that foundation would actually make our voting rights jurisprudence more coherent." She unveiled a chart included in her briefs but not yet discussed. "This analysis demonstrates that adopting the original understanding would affect only a limited set of voting restrictions, specifically those with the most significant disparate impacts. Most election laws would remain unchanged." Justice Kavanaugh, appearing uneasy, pressed further. "Congresswoman, even if we find your historical argument convincing, what's the limiting principle? Would this invalidate all voter ID laws, for instance?" "No, Justice Kavanaugh," Crockett responded firmly. "Only those meeting the statistical threshold, where the state fails to show a necessary and compelling purpose. Many voter ID laws would still stand if states provide free IDs and ensure equal access." She anticipated their questions, addressing potential challenges before they surfaced. The gallery watched in awe as Crockett skillfully countered each concern. Chief Justice Roberts, known for preferring narrow rulings, asked, "Couldn't we decide this case on limited grounds without reworking our entire voting rights framework?" "Mr. Chief Justice, you could," Crockett replied. "The statistical evidence alone under existing precedent would justify a ruling in our favor. However, I respectfully suggest that the historical evidence offers the court an opportunity to bring greater clarity and consistency to an increasingly fragmented area of law." Then came the moment that silenced the courtroom. Justice Breyer, who had been reviewing the document during Crockett's presentation, closed his binder and addressed his colleagues. "I've spent nearly 30 years on this court, studying the original meaning of our Constitution's protections for voting rights," he said, his voice resonant. "In all that time, I've never encountered historical evidence this compelling on this specific issue." The statement lingered, Breyer, known for his pragmatic rather than originalist stance, was validating Crockett's argument on originalist grounds, speaking directly to the conservative justices in their own judicial language. Congresswoman Crockett has not only uncovered a historical record, previously unknown to this court, Breyer continued, but she's shown how it can fit into our existing framework without causing the disruption some might fear. Justice Alito, visibly unsettled, broke in. Justice Breyer, are you suggesting we overturn our decision from 2 terms ago based on a document that wasn't even part of the original briefing? Before Breyer could respond, Crockett stepped in. Justice Alito, if I may, I'm not asking the court to overturn that decision. That case dealt with whether discriminatory intent was required, and the court said yes. I accept that ruling. Her tone was steady but resolute. What I'm showing is that the statistical evidence here meets that intent standard when properly analyzed. The historical context simply explains why that framework aligns with the 15th Amendment's true purpose. It was a masterful reframing, one that acknowledged the court's authority while subtly reshaping the foundation of the debate. While guiding the justices toward a ruling in her favor, she presented an approach that wouldn't require them to overturn their own recent precedent. Justice Breyer nodded approvingly. Exactly, he said. We wouldn't be reversing our precedent, only applying it with a fuller understanding of the constitutional clause in question. The atmosphere in the courtroom had completely changed. What began as what many assumed would be a routine argument from a relatively inexperienced congresswoman had evolved into a remarkable lesson in constitutional interpretation. One of the court's most respected justices was now openly supporting her reasoning. As Crockett's allotted time came to an end, Chief Justice Roberts thanked her, his tone far more respectful than when the session began. The court appreciates your detailed presentation, Congresswoman, he said. Crockett gathered her notes, exchanged a brief nod with Justice Breyer and returned to her seat. The opposing counsel, clearly unsettled, approached the podium next. He had prepared to challenge typical voting rights arguments, not an originalist, historically grounded argument endorsed by Justice Breyer himself. In the press gallery, journalists were already sending breaking updates to their editors. Something unusual had taken place. Headlines were practically writing themselves. Breyer backs Crockett's constitutional argument. Justice and Congresswoman form rare alliance on voting rights. Yet, what followed behind closed doors was even more extraordinary. 3 days later, the Supreme Court's press office issued a rare announcement. The justices had requested additional briefing on the historical evidence presented by Congresswoman Crockett. Legal scholars across the political spectrum recognized the significance of this move. The court seldom sought further information after oral arguments, and when it did, it usually meant a major shift in judicial perspective was underway. Inside the Supreme Court, Crockett's performance continued to resonate. Sources described the post-argument conference as unusually tense. Justice Breyer was more forceful than we've seen in years, one insider reported. He said that ignoring Crockett's historical evidence would be an act of intellectual dishonesty. Strong words from a justice long known for his collegiality. Meanwhile, back on Capitol Hill, Crockett's office was inundated with calls from major news outlets. CNN, MSNBC, and Fox News were all requesting interviews. Her social media presence exploded overnight, with Dr. Crockett Constitution trending nationwide. I just presented the facts and the law, she told reporters gathered outside her office. The Constitution doesn't belong to one party or ideology. It belongs to all Americans, and its protections should apply to every voter, regardless of race or zip code. Conservative commentators initially tried to downplay her performance. Political theater from a freshman congresswoman, one Fox host remarked. But legal experts from both sides of the aisle disagreed. Harvard law professor Alan Dershowitz, not known as a liberal partisan, appeared on CNN saying, Congresswoman Crockett presented a brilliant blend of historical context and constitutional reasoning. The court will find it difficult to dismiss evidence this compelling. Prominent conservative scholar Randy Barnett tweeted, As someone committed to original public meaning, I find the rediscovered 15th Amendment debates fascinating and potentially transformative for voting rights jurisprudence. Within the court, opinions were divided. Justice Thomas, initially skeptical, instructed his clerks to verify the authenticity of the documents and study their context. Justice Barrett, whose own academic work Crockett had cited, was reportedly re-examining the data through this historical lens. 2 weeks later, Justice Breyer made an unusual appearance at a judicial conference at Yale Law School. Although justices rarely comment on ongoing cases, he spoke broadly about constitutional interpretation. At times, we encounter new evidence or analysis that challenges our established views. When that happens, intellectual honesty demands that we reassess whether our precedents align with the Constitution's true meaning. This isn't about politics, it's about fidelity to law. Everyone present understood the implication. Without naming Crockett or the case, Justice Breyer was clearly signaling that her arguments merited serious consideration. The political consequences were growing. Voting rights groups rallied behind Crockett, with one launching a national campaign titled "Stand with Jasmine" to emphasize the case's importance. Civil rights leaders held prayer vigils outside the courthouse. Former President Barack Obama praised Crockett's intelligent and principled advocacy in a tweet that went viral. Meanwhile, Representative Jim Jordan appeared on Fox News to criticize Crockett, calling it another attempt by the radical left to federalize elections. When the host asked him to respond to the historical evidence Crockett had presented, Jordan hesitated. I haven't reviewed those documents personally, he admitted. 3 weeks after oral arguments, the case took a major turn. The Washington Post released an in-depth investigation confirming the authenticity of Crockett's historical documents. They had been discovered in an uncatalogued collection of papers belonging to Frederick Douglass, who had witnessed many congressional debates over the 15th Amendment. The Post's headline read, "Crockett's bombshell evidence confirmed authentic by historians." That same day, in an unusual move, Justice Clarence Thomas spoke at a Federalist Society event. Though he did not reference the case directly, he discussed the value of understanding the Constitution's original meaning. When clear historical evidence reveals the original public intent of a constitutional provision, he said, judges have a duty to align their interpretations accordingly, even if it means re-evaluating precedent. Legal observers were stunned. Was Thomas, one of the court's most conservative justices, signaling possible support for Crockett's argument? The speculation intensified. 45 days after oral arguments, the Supreme Court announced it would release its decision the following Monday. The lengthy delay suggested complex opinions were being drafted and that votes may have shifted during deliberations. On the eve of the ruling, Crockett appeared on 60 Minutes. "Whatever the court decides tomorrow," she said calmly, "we've already changed the national conversation about voting rights. These aren't abstract legal principles. They determine whether millions of Americans can exercise their most fundamental right in a democracy." By Monday morning, crowds filled the steps of the Supreme Court, hours before the decision's release. News networks were broadcasting live, and Scott's blog crashed under heavy traffic from users refreshing for updates. At precisely 10 a.m., Chief Justice Roberts began reading the majority opinion. In a 6-3 decision, the court rules in favor of the petitioners, he declared, sending shockwaves through the courtroom. Crockett had not only won, but had apparently persuaded at least one conservative justice to join the majority. Roberts continued, explaining that while previous rulings required proof of discriminatory intent to invalidate voting laws under the 15th Amendment, the evidence presented in this case offered critical historical insight into how intent could be demonstrated. The court adopted a modified standard. When data shows a severe disparate impact on minority voters, the burden shifts to the state to prove its procedures are essential to achieve a compelling governmental interest. This approach, Roberts stated, aligns with both recent precedent and the original understanding of the 15th Amendment, as reflected in congressional debates from its adoption. Justice Breyer wrote a concurring opinion, summarizing it from the bench, an honor reserved for landmark cases. Today, the court shows that true constitutional interpretation is not bound to any one judicial philosophy, Breyer said. Representative Crockett's research and legal reasoning remind us that the Constitution's voting protections are deep and substantive, not merely formal. Unexpectedly, Justice Barrett wrote a separate concurrence joined by Justice Kavanaugh, stating that the petitioner's statistical model, combined with historical evidence, created a workable framework that respects both state authority in elections and the right to vote free from discriminatory barriers. Justice Alito, joined by Justices Thomas and Gorsuch, wrote the dissent. Today's ruling departs unnecessarily from recent precedent, relying on historical evidence that, while interesting, should not override established jurisprudence, Alito argued. As news spread, Crockett's phone rang nonstop. President Biden called to congratulate her on the historic win. Civil rights advocates celebrated the decision as the most consequential voting rights ruling in decades. Law schools immediately added the case to their constitutional law syllabi. When Crockett emerged from the courthouse, hundreds of supporters cheered. Reporters shouted questions, but she raised her hand for silence. Today, the Supreme Court affirmed what should never have been in doubt, she said firmly. The Constitution protects every citizen's right to vote regardless of race and prohibits states from creating systems that deny that right under the guise of neutrality. This victory isn't mine, she continued, her voice steady but powerful. It belongs to every American whose vote was threatened, the elderly person without nearby ID access, the parent who can't stand in line for 8 hours, the student whose campus polling place was closed. That evening, back at her congressional office, Crockett found a handwritten note waiting. Recognizing Justice Breyer's handwriting, she opened it. Representative Crockett, it read, in nearly 3 decades on the court, I have rarely seen advocacy that so perfectly united historical scholarship, constitutional principle, and practical insight. You've not only changed this case, but possibly the future of voting rights jurisprudence. The Constitution and the country are stronger because of your work. With respect, Stephen Breyer. Crockett folded the note carefully and placed it in her desk. Turning to her team, she said, We've won a battle, but the fight for voting rights continues. Let's get back to work. In the months that followed, the decision reshaped the political and legal landscape. States with restrictive laws rushed to amend their systems. Academic journals published analyses of the new framework, and law professors developed case studies based on Crockett's strategy. Crockett became a national figure, discussed as a possible Supreme Court nominee and invited to speak at top universities. The once underestimated freshman congresswoman was now teaching masterclasses on constitutional advocacy. A year later, Justice Breyer announced his retirement. At his farewell ceremony, he referenced the case directly. Even after decades on the bench, there's always more to learn. Representative Crockett reminded me that true constitutional interpretation demands humility and moral courage. Her advocacy remains one of the defining moments of my career. When asked about his remarks, Crockett smiled. Justice Breyer showed us the Constitution isn't frozen in time, its core protections live on. When great legal minds approach it with honesty and integrity, justice prevails. I'm grateful to have argued a case worthy of his intellect and ideals. The story of Jasmine Crockett and Justice Breyer will be studied for generations. A reminder that sometimes one advocate with the right argument at the right moment can alter the course of constitutional history. Thanks for watching this inspiring story of how Jasmine Crockett's brilliant advocacy earned Justice Breyer's respect and reshaped voting rights in America. Don't forget to like, subscribe, and hit the bell icon to stay updated with more powerful stories of justice and constitutional milestones.